Let me get started. My name is, still as Steve indicated, I'm Paul Presti. I'm a retired intellectual property lawyer. And since I retired, I have been a counselor for SCORE, often called in by other SCORE counselors when they have issues involving intellectual property. I think I've been able to help a number of SCORE clients make good business decisions involving intellectual property, and that's what I'd like to do here today with those of you on the webinar. I cannot give legal advice, but I can help you make good business decisions, and that's what SCORE is all about. With that, I will get started. As an overview, I'd like to start with a couple questions, just so we get a little background as to what we're going to talk about. And those two questions are, what is intellectual property, and why is it important? As I'm sure you may know, what intellectual property is it's a number of legal processes by which business owners can acquire rights to protect their interest, whether the interests are in trade secrets or in new, unobvious machines, processes, compositions, or whatever, which gets you into patents. Ornamental designs can be protected. Trademarks, I mentioned plant patents as well, trademarks, copyrights. These are all forms of legal processes that give you rights to protect your business in some aspect of your business. And that is what intellectual property is. IP is important because it protects many things, including your lead time. That is the time that you have as an advantage because you've done something different or new over those who try to use the same business or make similar products or competitive products. Protects your identity so that people know who you are and that you are the source of this product or this particular business service. It protects your innovativeness. And most businesses depend on being innovative for their profitability, and they want to consider themselves unique in one form or another. And intellectual property provides the legal processes to try to protect those things. So that is what intellectual property is. But most importantly, intellectual property protects your profitability, and that is why it is important and should be something that you want to think about in all of your business planning. Looking at the individual kinds of intellectual property and why they are important. Trade secrets, for example, protects your intangibles, your marketing data, your technical data, your business plans, your sources of information, your route lists, anything that's of interest that something that you want to protect so that you retain that advantage having that over others. Why are patents important? Well, patents, usually we think of utility patents, which protect new and unobvious machines, composition, processes, and so forth. And it gives you, the owner of that patent, the right to exclude others for that particular product or composition or machine for at least a period of time. And the hope that is a consideration of patents, that is for a period of time. And patents also are important to protect improvements in those things, not just the item itself, but improvements in those processes and compositions and machines and so forth. Design patents are important to protect the ornamental designs of useful objects. For example, you may have a lamp with a very interesting ornamental design. The lamp itself is a useful product, but the ornamental design is something you can protect with a design patent. Plant patents protect certain kinds of plants, particularly those that are asexually reproduced. And if you're in that business, it's important for the plant patents will protect you. This is the kind of thing, the kind of plants that come from bulbs, root cuttings, or grafting that produce genetically similar progeny. And if you're in that business, plant patents can be important to you. Trademarks are important because they identify the source of the goods or services which you're providing to new and repeat buyers. They encompass the goodwill that's associated with that identity, and they protect that goodwill. And they provide you the exclusive right to the use of that mark for the goods and services that are identified with the mark. So in that way, trademarks can be a very important part of your business. And finally, copyrights. You have literary works that are part of your business, or you produce literary works, including software, visual, dramatic, musical, photographic works of art, even electronic circuit mask designs, sound recordings, architectural drawings. All of these things are protected by that legal process that we know as copyrights. I mentioned software. Of course, it's important, and this question comes up often. Yes, software can be protected by copyright, but what's protected is not the underlying logic of the software, but only the way it's expressed. So if a customer or a competitor is able to copy your software exactly, your copyright will protect you against that, and you can enforce your copyright. It does not, however, protect the logic of the software. That's true of all forms of copyright. For example, copyright in a book protects the way it's expressed, but doesn't necessarily protect the underlying logic of what's in the book. You get into some issues in dramatic works of whether or not the way what's expressed in the book is part of what's protected by copyright, but that's a different issue and something comes up in that specific area for you to deal with separately. So all of these things are the ways that these different types of intellectual property are important to you. In the ways they protect your business, it depends a lot on the individual business, and some or all of them may not be relevant, or they may all be relevant individual things. The other aspect of knowing about these things is the defensive aspect. That is, others also have rights in trade secrets and patents and copyrights and so forth, and you do have to take that into consideration. We'll talk about that as we go through the further discussion here, but in general, I will be talking about it from the offensive standpoint, how it protects your business. You do want to think, however, defensively about how you may run into problems with the same protection that others have on their businesses. And this is continuing consideration. So that's pretty much an overview of what IP is and why it's important. And with that, I'd like to move on now to a deeper dive into the individual kinds of intellectual property and what they are, how they're acquired, what they mean, and what they can do for you or for somebody else. Let's start first with trade secrets. Trade secrets are important in a number of ways, but you have to realize that trade secret law varies a good bit from state to state. Historically, trade secret law was a matter of state law, and therefore there was some variation from state to state. And even now, if you go into state law, state court, you may find some differences from state to state. Now, many years ago, there was a uniform trade secret law developed for states to use, and many states have adopted their law to their trade secret law to that uniform law. Here on this slide, I've given you a citation to go to that uniform law summary, so that if you're looking into, you want to know to the extent to which your trade secrets may be protected or somebody else's trade secrets may be protected, that uniform law may be a starting point into what your state law, the state law that you may have to deal with. Roughly 7 or 8 years ago, 2016, Congress passed a federal trade secret law. And here again, this raises some more options for you if trade secrets are important to you. What, among other things, the federal trade secret law is important because it gives very specific definitions of what's protected how it's protected, and it is uniform then across states. Of course, you have to be doing business in interstate commerce in order to qualify for that. Another aspect of federal trade secret law, which is important, is that it gives you access to federal courts, where it's often is something that helps you with jurisdiction. It helps you with maybe a more sophisticated court to look at your trade secret or deal with your trade secrets. Here again, on this slide, you have a site to the federal to an article by a group called upcounsel.com, which is very good and gives you a good overview of trade secret law, should that become important to you. You're digging down into trade secrets. What is trade secret law all about? Can be very important to you, because trade secrets relate to just about anything or information or idea which is commercially valuable or economically valuable for a business. So as I said, when we talked about why are trade secrets important, that can be data, it can be machines, it can be plans, it can be business plans, it can be sources of information, it can be customer lists, just about anything that's a piece of information or anything that is of economic value to a business can be considered a trade secret, and has two very important aspects. However, first of all, you must be able to prove that it's confidential. That is, when you're dealing with employees, when you're dealing with customers, you must always maintain the confidentiality of that trade secret. And that means your internal documents or documents that you're sharing with somebody else, you want to make sure they're marked confidential so that you have a way of proving that you protected the confidentiality of the trade secret. This becomes important when you're dealing with someone, when you want to actually disclose something to them in order to advance your business purpose, but in order to do so, you have to disclose confidential information. Or in the other direction, you may want to receive somebody else's confidential information so that you can make some business decision. So in all of these cases, the protection of the trade secret depends on it being confidential, confidentiality being maintained, and it being provable. One of the important aspects of trade secrets, however, is the period of protection can be indefinite. As long as that information remains commercially valuable and confidential, it will be protectable. That means you are protected in the way misuse of trade secrets often occurs is through former employees, customers who may have learned things that they shouldn't have learned. You have to be able to prove that the information was confidential and it was misappropriated, but if you can do that, then the time period for protection is indefinite. Mention that when you want to disclose information to somebody for your good business purpose, or they want to disclose information from you and you want to receive it, you often get involved with non-disclosure agreements, which are pretty common. As a score counselor, I've often been asked, well, can't we just take a non-disclosure agreement, standard NDA off the web and use that? And my advice usually is you want to be careful of that, because your NDAs really need to be customized. And you want to consider whether you're receiving information or disclosing information. Whose information is it? And with respect to the different aspects of that, you want to consider the reason for disclosure. And in order for the NDA to be enforceable, you want it to have value as a contract, which means there must be mutual consideration. There must be shown right in the NDA why it's being disclosed and the value, and why the person or the entity to which it's being disclosed wants to enter into this NDA, so that there's mutual value in the contract. And when that's shown, that makes it an enforceable contract. That's one of the points to consider in an NDA. That is the reason for both parties to enter into the agreement. Some other points to consider if you're looking at an NDA is you want to make sure the confidential information is defined so that both parties know what's protected, whether it's written or not, how it's being disclosed. Ideally, the NDA would include some reference to the term of the limitation. Now, how long is the person or the entity receiving the information prohibited from disclosing it or using it in some way other than provided for in the NDA? Another thing that should be in the NDA is the extent of the permitted or limited sharing of information. To whom may the receiving party disclose? How may the receiving party use the information? And that ought to be part of the NDA. And generally speaking, you'll want an exclusion for prior knowledge. That is, even though something is disclosed as confidential, the person receiving it wants the opt-out if it turns out that it wasn't really confidential, but that same information was available publicly, then it should be excluded from the provisions and the protection of the NDA. And so these are all things that you may want to consider if you're going to enter into an NDA. There's also another aspect that you'll often see, and that is a statement that if the trade secret is misappropriated, the damages that might be recovered, monetary damages that might be recovered, would be insufficient because of the value of the trade secret. It's so important that money alone won't suffice, and what you really need is what the party disclosing the information really needs is an injunction. Well, in that case, in the NDA, you'll sometimes see what's called an assumption of insufficiency of compensatory damages for infringement, so as later to justify an injunction if that becomes necessary. These are all things to think about when you're entering an NDA, and you want to think about it from the standpoint of whether it's your entity that's disclosing the information and your information to be protected, in which case you want these, as all of these particular things, to be defined in ways most favorable to you. On the other hand, if you're the one receiving information, confidential information from someone else, then you want to have it as to the extent possible to protect you, so that you can't be accused of misappropriation or misuse of the information. And so it depends on whether you're receiving. And often there's mutual disclosures, in which case both parties have an interest in whether or not the terms are very narrow or very broad. Generally things that you want to consider when you're entering into an NDA. That pretty much wraps up what I was going to discuss as far as trade secrets are concerned. Are any
Did you want to
questions
take-
now or later about trade secrets? We can get into that.
Did you want to take any questions now, Paul? There are a couple
If you have questions on trade
Q&A.
secrets, why don't we deal with that first?
Well, they aren't specifically on trade secrets. You still want to review
Well,
them?
then let's go on and see when we get into the area of the questions. They may
Okay.
be more relevant. We may be able to answer the questions even before we deal with them specifically. How's that? So
Okay.
we just move on?
Yep, one has to do with service marks and the other on copyrights.
Okay, well, the question on service mark, that's trademark. We'll get into that eventually.
Okay.
The order that I have the slides in, the next thing that I was going to deal with is patents. There are various kinds of patents: utility patents, design patents, I mentioned earlier, plant patents. There's also foreign patents, because patents generally provide rights in the country where the patent is issued. For example, there's US patents. There's also European patents and Chinese patents. So if business is such that you want to protect your invention or your design or whatever in other countries, then you must file foreign patents as well. And there's ways to do that. We'll talk about that in a minute. But you do have to realize that when you're talking patents, you're talking about country by country or area or territory by territory protection. The patents that were thought about most often are what we call utility patents, which deal with new and unobvious machines, compositions of matter, processes they're tangible, new, and unobvious. And that's the most common kind of patent, called utility patents. And the way you get into that process is by filing an application. I just want to deal with that to begin with, because applications in the US are of two types: provisional applications and non-provisional applications. The provisional application basically sets up a 12-month period from the filing date for you to tighten up your protection, to think more about it, maybe invest a little more in the protection, because provisional application doesn't have to adhere to the rigid formality rules of the non-provisional, and therefore often you'll give advice to file a provisional application to begin with as a starting point. And that can be a good strategy, but you must realize that there's a risk of that, because even though the provisional application can be filed more simply and less expensively, there is a risk that unless the invention that you eventually want to protect with a non-provisional application is fully disclosed in the provisional, that you won't be entitled to the filing date of the provisional, which is the reason for filing a provisional in the first place. So you do want to make sure, if you're advised, or if you decide to go the route of filing a provisional application, to make sure that the invention to be protected is fully disclosed in that provisional application. That's sort of a sidelight about applications themselves. Moving on to patents, what are they? What's their function? What do they do for you? Well, they provide a period of exclusivity for you, a period during which either your period of exclusivity is respected and others do not use whatever it is that's protected by the patent, or if they don't respect it, if you are not able to exclude them from using it, then you may find it necessary to sue for infringement. Of course, that's an aspect of patenting that can be expensive and time consuming, but ideally the others will respect your right to prevent them from using, selling, importing, and so forth the claimed invention in the country where the patent is issued. And that is really what exclusivity is all about. It's the ability to exclude others from making, using, selling, or importing the invention which is claimed, and we'll talk about that particular limitation, in the country where the patent is issued, and for a period of years. A little background on this, what patents are all about. They're kind of a trade-off which governments provide, saying, if you'll take this novel idea that you have, this novel plan, this novel machine, this novel composition, whatever it is, and disclose it publicly in a patent, we will give you a period of exclusivity. In the US, it's 20 years from the earliest filing date. For a US utility patent, you have that period of exclusivity. After that, that information becomes public knowledge for the public good, and that's the trade-off on which patent law is based. So that right to exclude is good for a period of years, 20 years in the US from the earliest filing date, and it's legally enforceable at a certain cost and time and uncertainty, if necessary, if the rights are not respected. And however, it also provides the right to license or to sell if that patent is valuable to other people and they are willing to pay the patent owner for the right to use the invention. Then that patent becomes valuable as to be monetized for licensing or actually being sold outright. Caveat there, if as a new business, your end game is to think that you're going to be able to license the patent or sell a patent, you must realize that the probability of that is highly dependent on the state of the development. That is, while you may have filed a patent on the basis of it not being fully developed or not being reduced to practice, not having really developed a proof of concept, you're going to have great difficulty getting others to take a license or to pay you for that. So if your end game is licensing or selling of the patent right, you must realize that the probability of doing that is highly dependent on your state of development. Here again, you want to think not only offensively, how you may protect your own novel, innovative design, products, compositions, and so forth, but others may do likewise, and they may have a patent which dominates yours. In other words, they may have a broader patent going back further. So even though you may have the right to exclude others from using what your patent covers, you may not have the right to use it vis-a-vis somebody having a dominant patent over that broader concept within which your patent is based. So that's here again, what I'm suggesting is that you think both offensively and defensively when it comes to patent. If you want to know a little more about patent law, it's all in the US, it's all based on Title 37 of the US Code, and you can see that in this particular citation from Cornell Law. More information also is available on the US Patent and Trademark Office website, which is uspto.gov/patents. And you'll find a great deal of information there about patents and a great deal of information if you're thinking about trying to file your own application and so forth. So those sites may be useful to you. Let's talk a little bit about just what you can patent. First of all, I like to think of it as it requires something to be tangible. This is not a word that you'll find in the statute, but you want something that's not strictly mental or written. It must be something that involves hardware. It's tangible. It can be a process. It can be a composition of matter. It can be a machine. It can be improvements in those things. But I think of it as being something tangible. It must be reproducible. That is, it's something, even though you may file a patent based on an idea, where ideas themselves may or may not be patentable, you might have an idea which you can define in such detail that others can actually, with others just within their skill, typical common skill, can actually do what you're suggesting with the way you define your idea. And we call that reproducibility. That is, you must be able to define it in a way that others can actually use it, even if you haven't reduced it to practice. As I said earlier, it cannot be a product of nature. More important, and typically in the barriers that are most often presented if you're thinking of patenting something, are that what you have invented, what you'd like to protect with the patent, must be new. That is, we think of absolute novelty. If you have started to sell it, if you disclose it to somebody else in a way, in a non-confidentially, if you've published something about it, or if somebody else has published the same idea, then you don't have absolute novelty. There's some possible exceptions to this, but they're very narrow. So important that what you have invented be new. That's one of the first barriers to overcome. Another barrier, and probably the most common barrier to a valid patent, is that of unobviousness. And this is right in the patent statute. That is, an innovation or an invention cannot be patented if it is such that it would have been obvious to those skilled in the art with common knowledge. And for this purpose, it's important to know what is the prior art. What have others done in the way of what went into the invention that you're thinking of patenting? What are the components? What's the background? What similar products or compositions or methods have been used and published by others? And we refer to this generally as prior art. So in order to be patentable, what is claimed in the patent must be unobvious over the prior art. And when you go through the examination process in the patent office, that is one of the keys that you'll have to face, because the patent examiner will have done a search for what he or she believed to be the closest prior art, and very often will challenge the applicant to argue for the unobviousness of what is claimed over this prior art. Now, oftentimes it's very useful before the application is filed if you have a search made, where you do a search yourself, which you can do on the Patent Office website or in the internet generally, to see what it is that's closest to what has been invented, to what you'd like to protect with the patent, in order to try to anticipate what you're going to run into in the patent office. And so that you can define what you're trying to protect in a way that best proves its unobviousness or demonstrates its unobviousness, its differences from the prior art. That kind of a search is something that you may do yourself, as I said, or you can have professionals do it as well. But you'd often be well advised to have a prior art search before you actually file a patent application. It helps you better define the invention, helps you decide whether you're going to run into such a barrier that you may not be able to get a patent, or that it's going to be expensive to go through the arguments necessary to get a patent. The other point of considering unobviousness and novelty is that if you do get a patent and later on it turns out to be important to your business entity, you may be challenged by others who claim that it was granted improperly and that the patent is invalid, in which case you may be getting into litigation where you're again going to have to defend your position with respect to absolute novelty and unobviousness. So all of these things are important to take into consideration prior to the time you file the application, and throughout your business processes, whenever you're faced with whether your rights to exclude others is being challenged, or whether someone else is challenging your right to do something because of a patent they have, in which case you may want to raise these questions of absolute novelty or unobviousness about their invention. So these are all the prerequisites of patentability and things that you want to think about if you're thinking about, if you are considering going into the patent process or dealing with patents. As far as what patents involve, typically a patent has three primary sections. The claims, which come at the end of US patents, are like ordinarily a series of individual statements that define the subject matter that you're trying to protect. It's like a property description. It's a word description of what you believe to be innovative, new, unobvious, and so forth. And often there will be a number of claims for reasons which I will discuss this in a minute. Another important part of the patents are the figures. If your invention, the invention that you're trying to patent can be illustrated in any way, the patent office is going to require that you provide figures. And in the case of the non-provisional application, when you get into the formal patent process, those figures have to comply with certain formal regulations and rules, but they are an important part of the patent. They will include reference numbers, which are then used in the third section of the patent, which is the written description, in which you actually go through a description of the invention so that you enable others to use it in a way that enables not only lays the groundwork for the definition of the invention in the claims, but also provides the enablement, that is the ability, provides the ability for others to use your invention once the patent expires in 20 years, or immediately if they choose to try to use the invention. If your written description does not provide that enablement, that description that enables others skilled in the art to use the invention, then you will not have complied with one of the requirements for patentability. So these three sections are the things that a patent consists of, and just briefly what they look like. This, for example, is a patent example. First page of a patent provides a lot of bibliographic information about the patent. It will include one of the exemplary figures from the patent. It will include an abstract, a background of the original earliest filing dates, the priority dates on which the application is based, related information in the classes where the examiner searched. That's the first page of a US patent. I mentioned that one of the important sections of the patent are the figures, and that will usually come next. Again, for your formal patent application, your non-provisional, those figures will have to comply with certain rules. They'll include reference numbers ordinarily that are then used in the written description, which comes next. And this written description can be very lengthy. As I say, it has to be sufficient that it enables others to know what the invention is and to use it, and also to define just what it is that the claims are going to cover. And finally, you get to the claims. Ordinarily, numerous claims in the patent will be a varying breadth, beginning generally with very broad claims being narrowed individually by taking parts of the invention and defining them more specifically, so that the overall definition of the invention according to that claim is narrower. And what that does for you is provide a narrower but more protectable definition of the invention. Each claim is considered separately if you ever have to litigate, or if you're in licensing. And it may be that the narrow claims are more protectable, less vulnerable to being invalidated. And so for that reason, good patent strategy is to have a number of claims of varying breadth. And also, you may claim it in different ways. You may have an invention where you want to claim it both from the standpoint of a composition of matter and from a method of use. And you may have different claims approaching it from those different directions. So that's typically what you'll find in a patent, what you'll may want to include in a patent you're thinking of trying to obtain. Very often the patent claim, which is, as I said, hey, like, have a property description of the invention as you want to define your area of exclusivity. It can be very, very detailed. This, in the exemplary patent that I showed you a minute ago, this is the broad claim of that patent, and you can see that it can be very detailed. Patent application process sometimes often requires professionals, particularly drafting claims that comply with the rules for claiming. And even though you can get advice on uspto.gov that provides guidance, if you want to try to prepare and file an application yourself, you may often find it useful to engage somebody who is professionally experienced and licensed to represent you in the patent office, which of course can get to be expensive. It's possible you may find someone in that patent agent or a patent attorney or somebody who is licensed in the patent office to file a provisional application for you on the cheap, but you're going to get into a great deal more expense if you get into the filing of a non-provisional application for the long run, which you need to file in order to get a patent. And that can run up into the thousands of dollars. And it's something you may need to deal with if you're really serious about getting a patent. The other thing about the patent process is that once you file the application and go through whatever expenses involved there, and plus the government fees involved, the patent examination process, which may take 3 to 5 years sometime, is going to cost you, particularly for the professional advice you may need. You may end up spending as much for that as you did for the original patent filing. So for all of these reasons, you want to be careful before you undertake the idea of getting a patent. Patents can be very valuable, but they can be expensive. And for that reason, as I said earlier, you may want to do or have done a preliminary patentability search before you even go that route. The application examination process can be 3 to 5 years. If you start with a provisional application, you have 12 months from that to file your non-provisional and to file any foreign applications you want to file. Those foreign applications, for example, can be complicated in themselves and expensive. Most countries have systems similar to that of the US, but they do require separate filing and examination. There are some areas, such as in Europe, where you can get a European patent, which will cover most European countries. And there is a way through what's called a patent cooperation treaty to file an initial application, for example, in the US, which later can be the basis of multiple foreign applications a couple of years later. And this defers the expense of those foreign applications until you can better gauge the importance of the invention and how much you're willing to commit to it. So that's very often the route that people take to go for foreign patents is to go through what's called a PCT application in the US, and then through time periods that come up roughly 2 to 3 years later, you have the option then to go into whatever countries you want to file. And that again will depend on how much you're willing to commit to it. Individual applications in those countries or in Europe can be expensive. If you choose to file in Asian countries, for example, cost is going to be considerable just because of the translation cost. So much for patents. If there are any questions about patents, we can take those at the present time. Otherwise,
The 3 questions I have in the Q&A box, Paul, have to do with copyrights and trademarks and service marks.
Okay. Well, in that case, let's move on to trademarks. Here in this slide, you're seeing a lot of trademarks that I'm sure you're familiar with. These are all what are known as graphic marks. That is, the marks themselves depend on the graphic form of the mark, the way they're presented. Not shown here are another form of trademark called block letter trademarks. You can have a trademark in a word itself. And for example, a lot of these important marks that you see here shown graphically will also have a registration or a trademark in the word itself. And if you're looking at it offensively, you're coming up with a word that you want to use or a graphic that you want to use to identify your goods or services. You may want to think about its trademark value, both in the graphic form and as a block letter. One of the things that I've come up with often as a score counselor is small businesses will get started and they come up with what they believe to be a really good mark or phrase or graphic to identify themselves in the way they sell a product or a service. And then they become somewhat successful and they find that they're going to have problems with the use of a similar mark by someone else. And for that reason, I do suggest that if you're thinking of adopting a mark or a graphic phrase to identify the goods or services that you're going to be selling, you may want to do a search first on the internet, or again, go to uspto.gov, trademark part of that website will permit you to search prior trademark registrations, not necessarily marks that are used but not registered, which is another consideration, which you can find by an internet search. So I do suggest that if you're considering that, you want to look first to make sure that you're not going to find some other user getting in the way of the mark or the phrase or graphic that you want to use. Important point about trademarks and service marks, and let me say first of all that we talk about service marks interchangeably with trademarks because service marks are really like trademarks, except that they apply to the sale of services, not products. A trademark relates to the sale of a product, and actually a trademark must be used with a product on the product, whereas a service mark is a mark that must accompany the service in order to be serve as the identity for that service. But we use those names, service marks and trademarks, interchangeably, and I will not try to differentiate between them. Important thing about trademarks is that you have trademark protection immediately when you sell a product or a service using the trademark. That is, common law protection is automatic, but it's limited to the market area in which you use it and to the market for the goods or services on which it's used. So while you have some immediate common law protection, most often, eventually, you're going to want to register that mark, and we can talk about that separately. I do want to mention a caveat that trademark law is different and does not relate to trade names and registrations that you will may be required, particularly by states, for the naming of a fictitiously named corporation or company, or those trade name registration in many states are important, and you may be legally required to do that, but that isn't the same as having trademark protection. So you don't want to confuse the two. Finally, while I mentioned that you have common law protection for a trademark immediately when you sell a good or a service using a trademark, you may want eventually, and perhaps sooner rather than later, think about registering your trademark rights. Registration provides certain legal advantages we'll talk about in a minute, but it's important that you think about that early on in ways that protect your interest in the trademark. One of the important things about a trademark or service mark is that it be used as an adjective, not a noun. That is, if you take something, and then let's say it's years ago, and before Xerox came on the scene, you came up with the word Xerox as a new trademark. That's a great trademark. It's arbitrary. It's a new word entirely. In order to protect it as a trademark, you have to use it as an adjective. In other words, you have to refer to a Xerox machine or to a Xerox copy. And this is a good example of a trademark, which, if it's misused, might lose its value as a trademark. In other words, and early on, this was the case when Xerox was the only company making copy machines of that type, people would refer to the machine as a Xerox, or to a copy as a Xerox. Make me a Xerox. Well, that's an improper use of that trademark because you're not using it as an adjective. And so if and when you decide to select a trademark for a new business, you want to make sure that you always use it as an adjective. If it's used on a product, it must travel with the product, must be on the product or in a prominent way associated with the product or service. And it doesn't really become a trademark until you sell the product or service with the mark properly used on the good in conjunction with the service. Now that's important because your priority over others depends on your first use as a trademark. And that means that when you what you want to register the mark, it's going to depend on your first actual use, actual sale, and in the case of federal registration, interstate commerce. Now, when we talk registration, there is a way to anticipate that before you actually make the sale, and we'll get into that in a minute. But for the time being, let's just say for sure that you realize that a trademark can be a word mark in block letters, it can be a phrase, a symbol, a design. Ideally, it's arbitrary or suggestive, but not descriptive. And it's not confusingly similar to others that have used similar designs. You may be able to protect trade dress, for example, the restaurant front. In some limited cases, you may be able to protect color or a sound that's something which identifies the product or service with which it's associated. But these are pretty much exceptional, specific examples. You want to think about, if you're selecting a mark, the protectability of the mark will depend on just how arbitrary or fanciful it is. And if it is strictly arbitrary or fanciful, those are the best kinds of marks. You can think of some such as Starbucks and Polaroid and so forth. You can also think of things like Kleenex and Xerox, which tend to be used as nouns and which sometimes cause loss of trademark rights. So you want to avoid that. Other marks which can be strong or strong are what we call subjective, things like Coppertone, Greyhound, or weaker marks, still usable and protectable as trademarks and registrable as such, are descriptive marks, such as Honey Roasted Peanuts and Vision Center. It will be more difficult to protect this kind of a mark because you're more likely to run into other use of similar words or marks that will limit just how much protection you're entitled to. And finally, the least protectable kind of mark is what we call generic. And it's a generic word like shirt or soap or videotape. It's not going to be protectable. And there you run into the kinds of things where marks eventually started as trademarks, but lost their trademark value because they became known as nouns. And here again, we get into the adjective noun differentiation. Things like aspirin, dry ice, cellophane, I mean, one of a number of others, have lost their trademark significance because over time they began most common usage as nouns. Escalators, another good example, started as a trademark, no longer has trademark value. So if you're really good and select a good trademark that you like, you want to make sure that it continues to be used as an adjective. That doesn't mean that it has to be used as an adjective every time. You will talk about trademarks, products, sometimes referring to the trademark itself, but you do need to be careful in how it's used on the product so that you protect its general use as an adjective. Talking about registration. Registration is important because it does give you certain legal advantages if you ever have to import it, ever have to enforce it. First of all, there are state trademark registration forms. We generally advise against that because it limits your protection to that state. You're going to want interstate protection, therefore you want federal registration. And that requires the interstate sale of the product or service identified with the mark, meaning you can't re-register something until you have a first sale in interstate commerce. Now, there is a way to develop the priority for your registration prior to the first sale by applying for a registration based on intent to use. And this you can do. You'll go through the registration examination process just as if you filed a regular registration based on sale. But if you get to the point where the examiner is convinced that you're entitled to the registration, it will be held up until your first sale, and you will have to file affidavits or declarations saying you still have the intent to use, you still don't have a first use, and you can extend that time out so that if you ever get into a conflict about that trademark, and the question is the priority date to which you're entitled, that application based on intent to use will give you a priority date of when you file that. The basis or the reason why you want the federal registration is because it does extend coverage to the entire US, not just to the market area that you started in. And it does provide legal advantages in case you have to try to enforce the mark with litigation. So federal registration is valuable. You do want it. It's not immediately required when you start to use a mark, but you do want to think about registration if you're looking down the road a piece. And In that case, you may want to even file a registration application based on intent to use. Application is required in the USPTO.gov. There are ways to file yourself, and you can find information on that website that will help you file a registration application yourself. Very often, you're going to require the assistance of somebody licensed to represent you in the Patent and Trademark Office. And you can, again, as with patents, you can get into cost. Probably not as great as patent costs, but they can be significant. Like trademarks, like patents, trademarks require applications in each country because the value of the trademark is dependent on the use in which the country in which it's used. And in some countries, it's important the registration application be filed earlier because you can file registrations there prior to having your first sale. And in which case you may run into somebody else who gets ahead of you, filing a registration application in a particular country before you've gotten there with your application. And sometimes you'll find if the mark is really, really popular, there are shady kinds of entities that will file these applications just so they can hold you up and you get around the filing in that country. There are ways for coordinated filings in multiple countries as well. I won't get into that here. You're probably going to need professional advice if you want to do that. So much for trademarks. We're now getting into copyrights, and maybe this is the time to take some of those questions you
Yes,
mentioned.
there are like 4 questions, Paul. First is, if we're a service provider not selling any product today and we have a business name we want to federally protect, I presume this would be a service mark. But if in the months or years after applying for a service mark, we intend to or know there's a likely chance our service mark business name entity will also sell goods, would it be smarter to originally file the name as a trademark instead of a service mark?
Well, when you file a registration application, you have to identify the goods that you're trying to protect. So when you file that application, you may refer to the classes of goods that you'll see listed in the USPTO.gov website. And you'll identify, in this case, you can identify classes that include services as well as products in the single application. I believe you'd be entitled to do that in a single application. It's just that you must identify in that application both the goods and services and the classes of those goods and services for which you're applying for the registration.
And so you can effectively do both with a single registration then.
I'm pretty sure you can do that. Again, I wouldn't guarantee it, but I'm pretty sure you can include both goods and service classes in the same application.
Thank you. The next one is, I'm wondering to what extent you've observed successful trademarking when one files an application with a 2-word name without a space between them versus with a space. I've seen famous companies like Quest Diagnostics and many others with a trademark next to their name without a space. And I've assumed that this was the only way they could secure a trademark federally without causing confusion. Would it hurt our chances of trademark examiner approving our application if we first apply with a space between the words, and then if it's rejected, reapply without a space?
Well, when you look at conflicting trademarks, the key words are confusing similarity. Our customer is going to be confused. And I would think that with or without a space doesn't make much difference. If you take Quest Diagnostics as a good example, if a customer sees a product or a service sold by Quest Diagnostics with or without the space, they're going to confuse it with the registration that Quest Diagnostic has, whether or not there's a space in the registration. So I don't think that's going to make much difference. I think the question is whether or not it's going to be confusingly similar.
Thank you. The next is, what constitutes the sale? Is it the exchange monetary only?
Probably so. I think if you send a product to a friend in another state and say this is a sale, you might be called on to actually prove that that person or that entity bought the product so that it's a legitimate sale. I think that it's just a question of whether or not it's a legitimate sale, and if it's not, then it probably won't justify the federal registration.
Okay, thank you. Next is, if we want to trademark a three-word business name, but literally from pre-pandemic, when we had the idea and searched the phrase on Google, there were only 4 people on the whole internet called themselves that three-word noun with the word coach tagged on afterwards. But 2 years later, in 2022, there are now 40 people who have called themselves the same name with the word coach. Would the sheer volume of the people calling themselves this prevent us from incorporating and having the trademark examiner disqualify our application? Or, given the fact that none of those 40 people have incorporated that three-word name in any state, nor as a pending application on the USPTO, is it likely we may still have success if we file that name after incorporating today, for example?
Well, that's a pretty specific question. And what I mentioned in my introduction, I can't give legal advice, but I will say this. The issue is confusing similarity, as I said earlier. And with so many users of a very similar entity or a very similar group of words, I think that any additional use of that group of words is not likely to produce confusion between or among those users. So it seems to me that you're unlikely to be able to register it simply because it would be confusingly similar with the others.
Mm-hmm.
What you might find is you try to register it disclaiming parts of the mark, but even there, I suspect you're going to run into problems. I think that the others would have trouble claiming trademark rights in what they're doing, simply because the group of words is not exclusive to any one user.
Yeah.
So I kind of think that this is free for use. Now, adding the word coach doesn't help very much either, because others are already using the word coach. So it seems to me that this probably isn't even a trademark question. And as far as registration as a corporation, that gets into trade names. And it may be that in the state where you want to incorporate, no one else is incorporated with that name, and you may be able to incorporate it having that trade name. But that doesn't give, as I said earlier, it doesn't give you trademark rights.
Registration. Thank you. 2 more. With trademarks, if a third word is added, like the, to denote the 2-word noun is special and stands out, would that increase the chance of acceptance by USPTO on the first try relative to leaving the word the out? Or would it be wiser to first apply without the word the, and if rejected, add the word and reapply?
I don't know. You're getting into a specific question here. The extent to which adding the word the, THE, better identifies the product or service with or without that word. And I think that's a very specific question, probably depends on the particular mark involved.
Okay, thank you. Some more. How do you correct first in use application with intent to use on a registered mark application?
I'm sorry, could you repeat the question?
I'll read it as it's written. How do you correct first in use application with intent to use on a registered application?
I'm not sure I understand the question. If
information.
the person is asking whether in a registration application, you can amend it to state a different first use date. Honestly, I don't know the answer to that question. I think that probably depends
Yeah.
on rules in the trademark office, and you may be able to deal with that by looking at the rules in the USPTO.gov.
Okay.
Yes.
Uh,
Hi, can you
it-
hear me?
Yeah, Megan.
Oh, hi, and thank you so much. I was just to clarify the question, if you already have a registered mark application and you need to change it from being, used versus intent to use, does that kind of disqualify your mark? Or are you able to kind of, apply to change, it from being a first in use date to instead you were actually trying to intend to use it?
I think you're asking a very specific question that I don't think I can answer. You might find that you if you have an application pending, you probably have an examiner identified who's dealing with that application. And you might call that examiner and tell them what your problem is, what you'd like to do, and get some direct advice from the examiner as to whether or not they're going to permit it.
I see. Thank you.
Do you want to continue with, there's some more here?
More questions?
Yes.
All on trademarks?
Yes.
Okay, well, let's deal with them.
Okay, if a foreign company starts selling in a US with virtually the same name, just with a different letter and lowercase in the spelling, in the specific industry but different product and purpose of the product, is there any recourse? And if yes, how?
Again, the question comes back to, is it confusingly similar? If they're selling a different product, is that product in a common market? Is the kind of thing, is it a product that's likely to be sold alongside the product that the registration covers? If it's a completely different market, and I give you an example: Cadillac dog food. Does Cadillac dog food infringe the Cadillac automobile? Probably not. People who buy dog food don't think that it might also come from General Motors. On the other hand, there is a federal law called dilution. In that case, possibly Cadillac has a case for, if assuming this is all occurring now, without the history of how these names have developed, would Cadillac have a case to file to prevent the dog food use? And chances are it would come under this separate federal statute, which is to protect against dilution of only famous trademarks. But where you have the situation that you're talking about, not knowing what the product is and what the product that's being imported is, it's a question, are those products traveling typically sold alongside of one another? They're typically sold alongside of one another. It's more likely that it would be confusingly similar to permit that foreign import. If, on the other hand, they're in absolutely completely different fields and customers wouldn't necessarily identify one with the other, then maybe they can get away with it. You just don't know. It's very fact specific.
Thank you. Another one, could you clarify what is meant by you could just claim parts of the mark? I'm not sure what that's referring. Maybe a comment you made?
Well, a trademark registration covers a mark. Now, you might claim that individual parts of the mark are separate trademarks, but you'd have to have separate registrations for those separate parts. And I'm not sure that your use, because you'd have to use as individual marks as adjectives with the generic noun following. And that might not qualify as a trademark when it's used only in conjunction with the other half of the word.
Thank you. Another question, is a business license different from a service or a trademark?
Yes. Business license, I'm thinking you're talking corporate registration, a license to do business under a certain name. That is a trade name registration. It's not the same as a trademark registration.
There's another question, maybe a little more general. If we hire a lawyer, I know success on the first run depends on their extent of knowledge and experience, but in general, from what you've seen, what % of applications are fully approved after the first filing? 10, 50, 90%?
I'm sorry, I can't give you a percentage. I don't really know the answer to that. From my experience, yeah, it's probably down in the range of 10% maybe
Okay.
that are allowed in first action. You're talking patents, I assume.
It didn't reference, but yes, I would assume. Another question. I have been selling my own vegan cakes, which are new to the market, but intend to sell mainly as a box dry cake mixes. How do I protect my product or the processes? I use one natural ingredient that is not listed in the dry vegan mixes or recipes yet. Maybe that's a patent question.
Yeah, if you're talking a patent for recipes, those are generally pretty difficult kinds of patents to get because there's so many recipes that are generally known, and you'd have to look for what other recipes are available on the internet, for example, and have other people use that one element that you haven't used, and does that one particular component that you've added to the recipe make it, was it so unobvious to use that particular component? Again, you're getting into the obviousness question. Is it a particular spice, and is that spice used in other similar products? So you run into the same kind of analysis that you would have in any patent case during examination. You'd have to show that whatever you've introduced into the recipe, it was not obvious to introduce it and then produce a significant difference over what was in the prior art.
Okay, thank you. I have a couple of comments related to the question on the foreign filing. Carla clarified that one product is headwear for a human and the other is headwear for a horse, both in the horse industry. So the product searching brings both up. That was related to the, foreign.
To the trademark question, and I think that suggests that customers for those two products are probably familiar with both of those kinds of products, and therefore more likely, I would think, again, this is fact specific, but it seems as if it may be more likely that they would be confusing that when they saw the second product with a mark as had been used in the first product, thinking, it may come from the same source. And that's just the kind of question that arises when you are looking at possible trademark infringement.
Okay. Two more quick questions, and then we'll get back to you the rest of your presentation. I know COVID extended the timeline for approvals with the USPTO and other offices. What's the soonest a trademark we'd apply for this week would receive an approval from what you understand? And if they ask for revisions, how many more months till they review and approve the revision?
I really can't answer that question. Even if I could have answered it when I was in practice, I've been out of practice for a while, and it really depends on current state of the examination process in the Patent and Trademark Office. I just can't answer that question.
Does the USPTO provide any statistics like that?
I think you'll see a publication from time to time that talks about backlog and that sort of thing. Again, I would look on the USPTO.gov website for that.
Okay, last question. Regarding business names, what if we are filing a trademark for a name similar but in plural to another one in a foreign country?
if I understand correctly, the question is, we would like to protect a certain trademark with a registration application. And as far as we know, it would not be confusingly similar to anything used in this country, but it might be confusingly similar to something used in another country. If that's the question, it would seem that you may be able to get a registration in the US, but not in that other country.
Okay. Let's go forward then with the rest of your presentation. There's another
Well, the
question
other
here
area
about
that I was going to cover
copyright.
is copyright, so I'll move on with that. Again, if you're interested in copyright, you can see the full US copyright law, Title 17 of the US Code. And there's a site to it here on this slide. If you're looking to register copyright, again, on that, there's a site to give you some guidance on registration. Copyright registration is not difficult, and something very often can be done on your own without professional assistance. Moving on with copyrights, I think most importantly, you want to understand that copyrights protect how something is expressed, but not the idea or logic behind the creation. And this underlies a lot of the questions that arise in copyright law. First of all, as to what is covered by copyright law. It's technically defined as original works of authorship fixed in any tangible medium. And the kinds of works that are covered here are literary, musical, dramatic. You've seen the copyright notice on these kinds of things. Choreography, pictorial things, graphics, sculptural, motion pictures, all of these are subject to possible copyright protection if they are original works of the person applying for the copyright, or somebody who's been hired by the person applying for the copyright. There's also ways to protect sound recordings and printed circuit masks and architectural works with separate statutory forms of the copyright for those kinds of things. As I said before, all right, I guess I didn't say it before, a copyright is effective upon creation. If you are the original author of a copyright protectable creation, you have a copyright upon its creation. Now, this is something that goes back maybe 50 years. It wasn't true before that, but you do have copyrights immediately under common law. Now, or not under common law, under US copyright law, but you often see copyright mark used on goods. The copyright mark can be a C in a circle with the word copyright, usually together with the name of the owner and the date of first use. The point of marking like that is to put others on notice that the person who created this wants to protect it by copyright and will enforce its copyright. But that mark is not necessary because, as I said earlier, the copyright is effective upon creation. And again, registration is not required, but it is simple and inexpensive, and it is necessary if you ever wanted to enforce the copyright. What does the copyright do? It gives the copyright owner the right, exclusive right, to reproduce the copyrighted work, to prepare derivative work, to distribute and sell or rent the work, or copies of the work, and also the right to perform or display publicly works. And that's basically the exclusive right that the copyright owner is entitled to. And if someone does any of those things without authorization of the copyright owner, that's a violation or copyright infringement. And copyright infringement is something it's a legal right created to provide the exclusivity of the copyright owner. However, if it is violated and you want to enforce it, that means going to court. Copyright infringement does require first registration. Now, what sometimes occurs is the copyright owner won't necessarily have registered and then starts to see a violation and decides to enforce its rights. it can then go for registration in order to justify the litigation. The only difference being in that case, the damages which the copyright owner might obtain will be limited to the time after the copyright was registered. So there's reasons why you may want to register a copyright, but again, it's not necessary, except for enforcement. And finally, in talking about copyright, we often get into the issues of fair use, because a copyright is not violated when the use is what is known as fair use. And this is a fairly amorphous concept, subjective. For example, a review of a book, a review of a movie, parody of it, a criticism of it. These generally come under what are known as fair use. Can be used to refer to a copyrighted use in a classroom or for teaching. All of these generally are considered fair use. If you get into questions about using a copyrighted work and you want to know whether or not it comes under fair use, you look at the purpose and character of the use, the nature of the copyrighted use, the amount of substantiability of the use that you're making of the mark, and probably most importantly, the effect on the use of the mark on the potential market for, or the value of the work to the copyright owner. This is all very fact dependent, and you kind of feel your way through that. Okay. That pretty much summarizes fair use. As with other intellectual property rights, you have to realize that others have intellectual property rights too. As a startup business, sometimes you have sort of an immunity because you don't hit the radar of somebody whose rights might be infringed, but that sort of immunity is short-lived, so you want to be careful of relying on that. You want to realize that your right to exclude others from the rights that you have may not assure you of the right to use it if others have dominant rights. And I'm looking for those kinds of dominant rights. You want to look for the rights of third parties who may be impacted by your business, prospective competitors of your business, other businesses from whom you've copied something or you're deliberately trying to circumvent or overcome. All of those kinds of other businesses, those other third parties, are the third parties whose rights you may want to consider defensively in undertaking your business judgment in the area where intellectual property may be involved. That pretty much sums up what I have to say directly. As they say, I can take questions, but I hope that I've given you some introduction to the various forms of intellectual property and how it may impact your business and how it may help you make good business decisions where intellectual property is involved. As Steve will tell you, you will be receiving a copy of this slide set, and I'm sure that other SCORE counselors that you may deal with will know that, or you can inform them that they're welcome to bring me in for co-counseling whenever you would like to have that co-counseling or matters involving intellectual property. And in fact, you can contact me directly. I am available if you want to deal specifically with intellectual property matters. So with that, I will turn it back over to you, Steve. That's pretty much all I have to say.
Well, there's still a couple questions here on copyright, if you'll consider those. One is, what are the advantages and disadvantages in the long run of filing copyrights with our personal names versus filing them for ownership with our company? I know if you have investors, they'll want the business to technically own all of the intellectual property. So we'd save the money of transferring the IP we personally own to that of the business, but other pros and cons of personal versus corporate ownership of IP?
None that occur to me. I would think that owner is already pretty sophisticated about the fact that having their rights in the name of a company makes it easier to sell those rights rather than to have to go through the process of converting it to a business ownership and then transferring it. So it seems to me they're right on.
Okay. Can you copyright artwork images that have a trademarked word within the picture or image?
That's kind of looking for specific legal advice, but I would say that the issue there is whether you're misusing the trademark. And that depends on whether it's going to take any business interest away from the trademark. If it's disparaging the trademark, you might have a case for that. But if it's not disparaging the trademark and isn't going to impact the sales prospects for the trademark owner, I'm offhand, I would guess it's going to be fact specific, but I don't know that there's going to be a whole lot of impact there.
Okay. Comment is, I don't understand the startup immunity short-lived point. Could you elaborate, please?
Yeah, I would, as a startup, you're often operating under the radar. And so even though you may be infringing the rights of a third party, you may get away with it for a while just on the basis that you're under the radar. I wouldn't rely on that too much, because hopefully, if you're in a business, you expect to be successful, and the more successful you are, the more likely it is that someone else with rights that you're infringing are going to know about it, and you're going to hear about it.
Thank you. Last one on here is, how long is a copyright valid for?
How long does the copyright exclusivity remain?
I would think that's the question.
Yeah, you're stretching me a little bit here. I think it's a copyright owner. If it's an individual, it's copyright owner, life of the owner plus a number of years. If the copyright owner is not an individual, quite frankly, I better not try to answer that question. I would suggest you go to the copyright law in the US Code and find your information there.
Okay, thank you. Well, I think we've covered all of the questions that were in the Q&A box. So
Okay.
I want to thank you so much, Paul. I think that's an excellent overview, and I appreciate it. Like, we're
Well,
getting some
but
thanks here.
It's been my pleasure. I hope it's been help to people who participated.
Yeah, so I wanted to let everyone know that I'm going to launch a poll right now. And it's just a few questions so that we get a sense of if this was helpful or not, and are we providing the kinds of information folks need. If you would take just quick, short time to respond to that, we'd sure appreciate it. And if you were interested in mentoring, I wanted to provide some information here that would let you get access to the really talented people we have available to help. I would encourage you to take advantage of that. And the last slide, if you would go to that one. Could you advance it one more?
I'll get rid of that. Your screen sharing doesn't want to advance. There you go.
There you go. Yeah, all I wanted to do was to end with saying that if you have any interest at all in anything that SCORE has to offer, the website there and email and office, that please take advantage of SCORE. And with that, that's all we have. And I sure appreciate people participating.